Welcome to yet another edition in our video series where we look at law in general. We have a video where we introduced the distinction between substantive law as well as procedural or adjectival law. So this is a continuation from that one. And this time around, we are looking just at the introduction to South Africa's law of civil and criminal procedure, whereby we look at the distinction between these two a little further. And then I hope by the end of this video, you will have gained sufficient knowledge to be able to, study further on this matter of the distinction between criminal and civil procedure. Now, looking at at procedure generally, you will find that the law of procedure outlines the steps and pathways adopted by legal subjects to enforce their rights contained or expressed in substantive law sources, such as maybe the Constitution, or rights are acquired in terms of a contract, or maybe rights acquired in terms of the law of marriage, or what we call family law, or maybe arising out of a delict, where you have been accidentally or injured by somebody else, or maybe in the case of express or outright crime, as you would have in the case of a thief stealing your property. And we are saying that the law of procedure, it deals with how to enforce the claim for damages arising out of breach of contract or out of any of these causes of action that may arise from time to time from different causes of action. As a way of recapping, we need to just run down a distinction between criminal and civil proceedings, just to set things in context. Substantive law maps out the rights, but civil procedure and criminal procedure ensure the enforcement of the rights. You find that courts are a formal system of dispute resolution created by the state to avoid self-help by aggrieved individuals. And South Africa's procedural system is adversarial in nature, which basically means that the two parties to a dispute present their cases before a neutral judge, and each of the parties vehemently pursues and prosecutes their case, providing evidence, providing and raising argument, and trying to push for an outcome as much as they can. So basically, the two parties to the dispute, who are called the disputants, of course, they consist of the legal subjects who represent their version, they present their versions of the dispute before the presiding judicial officer or the judge or the magistrate. And then that judicial officer acts as a neutral umpire or a neutral arbiter or an impartial referee, if one could say, as each disputant presents evidence and argument in support of his or her cause and her case. And this court does not interfere with the process, but only ensures that the disputants adhere to the rules of court. You will notice that the magistrates court, the high courts, the Supreme Court of Appeal, as well as the Constitutional Court, have different rules that apply regarding how the action can be commenced and defended in that court. There's a lot. There are a lot of rules regarding, the court recesses and the return days, the dies indiciae, and so on. So it is in terms of those rules of courts that the different disputants pursue their cases, and we are saying that unless they deviate from the rules, the court does not interfere with the process. Of course, in exceptional cases, you find that the court may ex mero motu, that is on its own account or its own accord, call for evidence and witnesses, especially where it is in the interest of justice to find the truth with respect to a particular issue. But otherwise, being an adversarial system in nature, you find that South Africa's system does not encourage the participation of the court or the judge, who is just supposed to be a neutral arbiter, as we have already said. Of course, this is comparable to the inquisitorial procedure which is applied in the continental system of Europe, where you find that the judge is the presiding officer and he also calls witnesses and delves deeper, it descends into the arena as if he or she were the dominus litis or the owner of the suit or the case. But that's not the case in South Africa, where we are saying unless the prescribed rules contained in the relevant legislation and rules of court are deviated from, the court does not interfere with the processes at all. The cause of action determines the procedure to be followed. A divorce proceeding, or rather when somebody is calling or praying for divorce or pursuing a divorce action, they would tend to take the matter to the civil court, and they follow the civil procedure because of the fact that it is a civil or a private law matter, whilst the public law issues such as crime are prosecuted in terms of the criminal procedure in terms of public law. So the nature of the matter determines the procedure to be adopted, and the processes on criminal matters are commenced in criminal courts in terms of criminal procedure, and the processes on civil disputes are commenced in civil courts in terms of civil procedure. And you find that the same cause of action may result in parallel civil and criminal proceedings taking place side by side. Let us take, for instance, a person who sets alight and destroys by means of fire his neighbor's property. The neighbor can institute criminal proceedings by reporting the matter to the police, and then the matter will take on the route of a criminal prosecution in terms of criminal procedure. But that same aggrieved person whose property has been destroyed through the act of arson is still free to demand or to make a claim for damages and pursue compensation through civil litigation. So you find that pursuit of criminal a sanction against an accused person does not preclude, does not exclude the aggrieved person from pursuing delictual remedies or any other private law civil action to recover for the damage that they may have suffered. So just to summarize things, criminal proceedings are public in nature because they involve the state acting on behalf of its citizens. Of course, we are not oblivious here of the fact that in exceptional cases, in terms of the Criminal Procedure Act 51 of 1977, the law permits for private prosecutions by aggrieved persons, especially where the state issues a certificate that it does not intend to prosecute. This nolle prosequi certificate, where the state declines to prosecute for whatever reasons it may find, the private individuals or citizens who are aggrieved by the conduct may then pursue criminal prosecution on a private basis. Of course, that is subject to certain strict rules and standards that have to be met, but generally the law permits for that. So we are saying, as apart from private prosecutions, which tend to be very peripheral and exceptional and far between, we are looking here at prosecutions being done at the instance of the state as a bearer of sovereign power against the individual accused of the commission of a crime in terms of substantive criminal law. And you find that in terms of criminal procedure, the quantum of proof is guilt of the accused beyond reasonable doubt. In other words, the state of a prosecution must prove beyond reasonable doubt that the person accused of the crime has indeed committed that crime. So if there is any doubt, any slight iota of doubt that the accused may not have committed that offense for which he is charged, then the court must find, it must acquit the accused simply. It cannot, the court cannot convict where all the elements of the crime have not been proven beyond reasonable doubt, because that is the quantum of proof that is required in criminal proceedings. It tends to be strict as a way of seeking to protect the rights of the accused from, unfair infringement. This has been actually consolidated by Section 35 of the Constitution, which is a very express and elaborate catalogue of the rights of the accused. You remember that the result in a criminal conviction is a sentence or an acquittal. So whatever the prosecution pursues, at the end of the day, the court must either find the accused guilty of an offense and then sentence him, or it must find that the accused, the state or the prosecution has not sufficiently proved the guilt of the accused. In that instance, it must acquit them. And so once a person is convicted, we use the term guilty. They are found guilty of a crime. That's very important, because the word guilty of a crime is distinguishable in civil law, where we say somebody is not guilty of a crime but is liable for whatever damage or they may have caused. So that's a very important distinction there. The convicted accused is then sentenced to custody or receives some form of punishment, which could be a fine, community service, or suspended sentence. There are many competent sentences depending on the charge and the nature of the conviction, the charges that have been proved by the prosecution in court. And then, so much about civil proceedings. We can go on to look at so much about the criminal proceedings above. Now we can look at the civil proceedings, where we are saying they are based on a claim between two presumably equal private persons. Why we are saying they are presumably equal? Because in some cases you find that their resources are different, and in some cases the state can be a subject of civil litigation. In that case, in which case then it still remains the state. For us to assume that the state, which is maybe brought before a competent court, maybe let's say by a civil servant as an aggrieved employee, to assume that the state as an employer and that civil servant are equal is sometimes misleading, because for practical purposes you find that the resources they have And even the fact that one is a state make it almost an unequal relationship. It's a kind of an equal yoking between these two. So we are saying that it's a claim between two presumably equal private persons, and we are saying it arises from private law relationships such as a breach of contract, a claim for delictual damages arising from a road accident, divorce proceedings, or child custody, or some other form of commercial debt or transaction. And as we alluded to earlier on, the quantum of proof is a balance of probabilities in civil matters. And then the objective is not to establish guilt, but to establish liability of the defendant. Well, as for the terms, we are going to discuss them in one of the coming slides. Whether like we have said, we have a guilt defendant, no, the answer is no. And then, very importantly, let us outline the fact that a successful claim results in an award of damages or a dismissal of the claim, and it's done on a winner take it all basis or on a zero sum basis, whereby you find that if a plaintiff makes a claim and wins, then the defendant must pay. If the plaintiff cannot sufficiently prove their claim, then the defendant doesn't pay anything. So that is the nature. We are saying it's a winner take it all. And then we are saying a court may order specific performance to the losing party, which could be a way of an interdict or payment of an amount. We are saying this is specific performance in the sense that it's now the court declaring and telling one of the parties what to do. In some cases, it's just a declaration of rights, depending on the claim that was initially being pursued from the word go. A very important distinction between criminal proceedings and civil proceedings is the words or the terms that are used. For instance, you find that in criminal proceedings, it is the state that commences action on behalf of a complainant. The complainant in this case being the person who suffered the harm. For instance, if it's an act of theft, the complainant is the owner of the properties being stolen. So it is the state then that commences action on behalf of that complainant. And then, meanwhile, in civil cases, the person commencing action is called a plaintiff, depending on how the procedure, rather how the action is brought. So, because as we shall understand as we delve deeper into civil procedure, we have a distinction between processes commenced by way of action and those commenced by way of we have applications, we have summons. That distinction is clearly discussed in the videos that deal with that. So we are saying the plaintiff commences action in a private suit, and then as we say in criminal processes, we have the accused as being the person who is being charged with committing an offense, but we don't have any accused in civil action. We either have a defendant if the matter has been brought by the application, or it may be a respondent if, for instance, an appellant had commenced the action. So these terms are very, very important, and they are very distinct, and it always matters to understand them so that they are not used interchangeably to confuse the discussion. In this video, we have introduced criminal and civil procedure in South Africa. We begin by defining procedural law as a way of distinguishing it from substantive law. We have another video that looks at that distinction in greater detail. In this particular one, we canvass the distinction between criminal and procedural law, and then we outlined the role of the courts in the conduct of criminal proceedings, as well as in the conduct of civil proceedings, and of course, not forgetting to outline how the nature of the cause of action determines the choice of the court, as well as the choice of the process. For instance, if we are dealing with a theft, looking at the cause of action being a theft, then it goes without saying that we take the matter to a criminal court and we follow the court criminal processes. But what if it's maybe a divorce proceeding, or there's a breach of contract? You had a sustained contract with somebody, and then they're acting contrary to the terms of the contract. So you then decide whether you take it to criminal proceedings or you take it to civil proceedings. But we know from substantive law that breach of contract is a private law matter, so it goes without saying then that it is taken to or rather it is prosecuted through the civil courts and the civil litigation. We discussed the attributes of each procedure, that is the criminal procedure as well as the civil procedure, and we highlighted the terms or the appellations used to denote the parties in criminal and civil proceedings. Of course, having taken into account that the terms guilt, liability, and so on are used in specific situations. You can't just use them interchangeably between criminal and civil proceedings. Thank you very much for being part of this lesson and discussion. I hope it has proved to be highly enlightening to you. Looking forward again to sharing more videos with you. In the meantime, remember to subscribe to our channel as well as to share some of our videos. In fact, share all of the videos that you've watched, just as a way of promoting the work that we do as we continue to reach more people. Thank you very much.